Ms. Gonzalez.
Thank you, Chair Durbin, Ranking Member Grassley, and members of the committee. Thank you for inviting me to testify today. I am here on behalf of Public Law Center clients who are low income. The Public Law Center is a 501c3 legal services organization committed to providing access to justice for low-income residents of Orange County. Through PLC's Consumer Law Unit, we provide direct representation to assist low-income individuals with student loans as well as with bankruptcy. Our clients are usually over 35, sometimes over 50, and in far too many cases, over 60 and above. In all of these cases, our clients are struggling to make ends meet and have almost always suffered an unexpected loss of income, making paying their bills a challenge. When student loan borrowers come to PLC for assistance, we look first at non-bankruptcy alternatives, usually an income-driven repayment plan. But despite the availability of these plans, so many borrowers are unaware of IDR programs or find the application process confusing. And so for the most part, by the time they come to us, we're able to enroll most of these borrowers in an IDR program that provides a payment that they can afford. If we're not able to enroll them in an IDR program, other students have other options, such as the total and permanent disability discharge. In many cases, however, students enrolled in the IDR program are unable to make their monthly payments because paying 10 to 15% of their discretionary income is simply not possible given the high cost of living in Orange County, including childcare. Just to put things in perspective, Orange County is at 87%, the cost of living is 87% higher in Orange County than the national average. Housing costs alone are over 374% higher in Orange County, 374% higher. So discretionary income in Orange County is anything but. The failure to make their IDR payments results in borrowers defaulting on their student loans, and in some cases having their wages or tax refunds garnished, or having a federal judgment entered in against them, making them actually ineligible for IDR programs in the future. The borrowers who cannot afford their IDR plans have additional consumer debt, usually including medical debt, that they also cannot afford to pay. My heart breaks for Ms. Barta, as her story is one that I hear far too often through Public Law Center's work. Despite being so overwhelmed by debt, my clients, they hesitate to even bring up bankruptcy in a meeting with me. There is a stigma associated with filing for bankruptcy. These students, these borrowers understand that bankruptcy makes it harder to find a place to live and means they will be unable to access affordable credit for many years. Overwhelmingly, PLC clients are ashamed that bankruptcy might be in their future. They did not plan to be unable to pay their bills, and they see filing for bankruptcy as a failure of sorts. So for the most part, by the time a debtor gets to the point of considering bankruptcy and trying to discharge their student loans, they have exhausted their options for increasing income and decreasing expenses. In fact, borrowers we work with are often unable to afford rent in Orange County and end up relying on friends and family for free or reduced cost living. These debtors are often working as much as they can and usually have some limitations as to the type of work and how much work they can perform. These limitations, however, do not rise to the level of a disability, making it unable for them to engage in substantial gainful activity. Since 2012, PLC has provided approximately 5,000 bankruptcy consultations to debtors through our bankruptcy work. Out of these thousands of consultations, PLC has only filed 5 adversary proceedings in bankruptcy to attempt to discharge federal student loans. And that's because the undue hardship bar is so high that we don't believe these other borrowers would be able to successfully discharge their loans in bankruptcy. When PLC does decide to seek a discharge of federal student loans for a client, the complaints we file detail heartbreaking facts to support a finding of undue hardship. A client who relies on friends or family for housing because they cannot afford to rent even a room in a house, and who feels like a burden on their friends and family. A client who, despite being told by doctors that they should not work, continues to work in order to pay their bills, including their student loan payment. A client who has to deny a child a trip to the movies or toys because all of their income is spent on necessary expenses, including their federal student loans. Despite these facts, these discharge cases are always contested. Borrowers are made to justify expenses such as paying for internet service and question about their financial situations to such an extent that borrowers sometimes just want to give up. The current system is just not working. The fact-specific demands of the undue hardship analysis places a tremendous burden on debtors, the bankruptcy courts, and frankly, government counsel. The reality is that the undue hardship standard creates arbitrary, conflicting, and unfair results that negatively impact debtors. Most circuits, as Chair Durbin mentioned, use the Brunner test to determine whether a student loan should be discharged in bankruptcy. There are 3 prongs to the Brunner test. I'm not going to go into all of them, but I do want to focus on 2 of them. The difficulty in the undue hardship analysis usually comes from those first 2 prongs. Maintaining a minimal standard of living, and that the circumstances are such that this is going to continue for the foreseeable future is the second prong. For the first prong, minimal standard of living. So while being able to afford, not being able to afford your own place to live sounds like a borrower is unable to maintain a minimal standard of living, this is actually always a point of contention in these bankruptcy cases. The reasoning seems to be something like, but the borrower has a place to live that they don't have to pay for, so what's the problem? It's as if depending on friends and family for shelter in your 30s, 40s, or 50s is a positive situation. The second prong requires the court and the government to predict the future, in a sense. Based on the past, insert however many number of years here, will that be the same in the future? Here, excuse me. While borrowers have established years of hardship, this is also a point of contention. Because did the borrower do enough to increase their income? Surely the borrower will earn more money in 5 or 10 years. But the fact is that by the time the borrower comes to PLC and we have filed a case to discharge their student loans, the borrower has exhausted options for increasing their income and has hit their maximum earning potential. Reintroducing the temporal discharge option would remove the arbitrariness and unfairness from the undue hardship analysis by, in a sense, codifying the second prong of the Brunner test. If a borrower finds themselves in a situation where they have to file for bankruptcy 7 or 10 years after the student loan became due, they have then established the situation has persisted for a significant amount of time and will maintain for the future. It actually, I'm happy to hear that everyone seems to be in agreement. All of the witnesses here seem to be in agreement that reintroducing the temporal discharge will help borrowers unable to afford even an IDR payment. There also seems to be agreement that not only won't students rush to file for bankruptcy and discharge their student loans, but that the bankruptcy system has in place protections against the abuse of the bankruptcy process. Everyone also seems to agree that the current IDR program and the system of undue hardship, that they're not working. Something has to change. Low-income borrowers, many of whom are individuals of color, are trapped in a cycle of being unable to pay their federal student loans, even on IDR plans. They default, they have wages or tax refunds garnished, rehabilitate their loans if possible, and then fall back into default. For those borrowers who have no other option, being able to discharge their federal student loans in bankruptcy is the only way to truly have a fresh start and a chance at a financially stable future.
Thank you very much, Ms. Gonzalez. We appreciate your testimony.